Hi, good morning. This is another Supreme Court judgment. Citation is ITC Limited versus State of Karnataka under the Legal Metrology Act. The issue before the Supreme Court was whether inspection and seizure conducted by the officer of the LM Act, Legal Metrology Act, without obtaining prior warrant is unlawful or not. That was the question. Facts: ITC is engaged in the business of stationery items like exercise books, notebooks, pen, pencil, etc. An inspection was conducted by an officer of legal metrology, hereafter I will say LM department, at the premises of the company. Some books were seized for violation of LM packaged commodity rules. Pursuant to the seizure, a seizure notice was issued. A compounding notice was also issued. ITC filed a writ petition before Karnataka High Court alleging violations of Section 100 and 165 of Criminal Procedure Code relating to search and seizure and prayed for quashing the notices and release of the seized goods. Single judge of High Court accepted the contentions of ITC and quashed the notices and ordered release of seized goods. A writ appeal was filed by LM department. Division bench reversed the order of the single bench, stating that requirement of search warrant under CRPC does not arise when Section 15 of LM Act was invoked. Division bench held that Section 100 of CRPC will apply only in case of closed premises and not in respect of open premises. ITC's premises were open premises and hence procedure prescribed in CRPC will not apply. Division bench held that the authority under LM Act is duly empowered to inspect, search and seize without a warrant. So simply put, Criminal Procedure Code prescribes the procedure for inspection and seizure. So the authority has to go to the place, he has to invite the witnesses, he must obtain a search warrant from the magistrate. All these procedures are prescribed. So the division bench concluded no, that procedure prescribing getting warrant from the magistrate before a search, it will not apply to the open premises. So they can, under the LM Act, the authority has power to search the open premises without even a warrant. That was the decision of division bench. This was challenged by the ITC before Supreme Court. Supreme Court, on a perusal of Section 15 of LM Act, said that Section 15 mandates that there must be reason to believe both for conducting a search or inspection of premises and for seizure of materials. In addition, the officer must also comply with the provisions of CRPC relating to search and seizure. Supreme Court, after going through the definition of premises, said the word premises includes 1. Place where goods are traded or manufactured. 2. Place where they are stored. 3. Place where books of accounts or other documents are kept. 4. A dwelling house if any part of it is used for business. And 5. Even a vehicle used in the course of business activity. Supreme Court said Section 15 contemplates 3 different types of actions: search, inspection and seizure. 1. It authorizes an officer to enter the premises to conduct a search for recovery or discovery of any concealed material. 2. During such a search, inspect such materials, whatever is available on the premises. And 3. If the officer has reason to believe the material may be used as evidence, is empowered to seize it. These are the three components, three different types of actions which Section 15 prescribes. Section 15 makes it clear that 1. Officer must have reason to believe that an offence is committed or it is likely to be committed. And 2. The materials or evidence are lying in that premises. These two conditions. 1. He must have reason to believe that an offence is committed or likely to be committed. And 2. The materials or evidence are lying in that premises. These prerequisites are common to search, inspection, and seizure. Supreme Court held that the definition of premises and the phrase intended to take place within quote intended to take place reinforce that the procedure prescribed under CRPC must be followed with respect to goods stored in warehouses or godowns, whether open or closed. So now, if you remember the division bench judgment, if you recollect the division bench judgment, which said, no, the procedure prescribed in CRPC will not apply to open premises. Supreme Court says, no, whether the premises are open or closed, the procedure prescribed under CRPC must be followed. That is what the Supreme Court says. Supreme Court, on a consideration of the relevant provisions of CRPC and Section 15 of the LM Act, held that merely because a place is open at the time of visit, it does not mean that the requirements of CRPC can be bypassed. Any officer intending to conduct a search or inspection and effect a seizure must necessarily follow the procedure prescribed and cannot forcibly enter premises without a warrant or without recording reasons. In some cases, the officer can record reasons and he may enter the premises forcibly without warrant. So that is why it says or without recording reasons. These safeguards are given to prevent arbitrary action of the authorities. Even in cases of searches conducted without warrant, the officer, after recording his reasons in writing and specifying as far as possible the thing for which the search is to be made, he can conduct or cause their search at that place. So he must record the reasons, even when the situation warrants that he has to search the place immediately. It is imminent. So then he must record the reasons before going for the search. Supreme Court said that to conduct a search or inspection, not only a warrant is ordinarily necessary, but there must also be reasons to believe that such a search is required. Then Supreme Court noted the various judgments of the earlier Supreme Court judgments. The gist of those judgments are 1. The reasons necessitating the search must be relevant and must reflect application of mind. It cannot be based on mere presumption or extraneous consideration. That is point number 1. So the reasons must be relevant. You cannot just irrelevant reasons or fishing inquiry. You cannot go and search. That is point number 1. Point number 2. There must be application of mind before seizing goods, materials, or documents during search. A rational nexus must exist between the article seized and the contemplated violation under the applicable provisions. That is also necessary. You cannot seize whatever is available and then take it. It must have a rational nexus. 3. This is very, very important and interesting. Various special enactments like Income Tax Act, Customs Act, Goods and Service Tax Act, NDPS Act, and other acts contain provisions relating to search and seizure. In all these enactments, the procedure prescribed under CRPC must be followed unless the provisions of the CRPC are explicitly excluded. So, even under the Goods and Service Tax Act, Customs Act, Income Tax, you can conduct search and seizure, no problem. But you must follow the procedure prescribed under the CRPC. You cannot just like that enter the premises and seize the goods. That is also a very, very important point to be noted. These are all the judgments of earlier judgments of Supreme Court. Then Supreme Court said, in the present case, the search was conducted without a warrant. No reasons were recorded, either for conducting the search or inspection or for seizure of goods. Therefore, the search and seizure are clearly vitiated by procedural violations. Supreme Court held that observance of due process of law must be followed. It is a legal necessity to ensure that the action of the authorities does not result in manifest arbitrariness or abuse and misuse of power by the authorities to conduct inspection, search, or seizure. When the law prescribes a particular procedure to be followed while taking a particular action, the same must be strictly adhered to, strictly followed. Supreme Court said it is a settled law that where the initial proceedings are vitiated, all subsequent proceedings are unsustainable. Any act in violation of law cannot be brushed aside on the ground that no prejudice was caused. Every violation of law is deemed to cause some prejudice. Again, I repeat, every violation of law is deemed to cause some prejudice. On the facts of the case, Supreme Court noted, there is nothing on record to suggest that the goods in the container differed from the labels on the container, either in form, quality, or weight. So everything is correct. The seizure measure only noticed that packages lacked clear and conspicuous declarations. Rule 24A of the LM Packaged Commodity Rules mandates that the declarations on wholesale packages to be printed and not affixed by way of label. The alleged violation was only a technical violation. It is technical in nature. The clarification notification issued said that there was no bar in affixing labels on the wholesale packages. So that was also watered down. In the present case, the officers of LM department violated section 15 and the procedure prescribed under the Criminal Procedure Code. There is nothing on record to show that the search was imminent, which justifies dispensing with search warrant. On the same day of search, a compounding notice was also issued to ITC to respond within 15 days. Taking all the above into consideration, Supreme Court quashed the notices and orders issued by the LM department. So, my comments recently, I also put that video. Yeah, there was a search conducted at the advocate's office. They entered the office, searched all the documents, including the CPU and whatever is available, they have taken, saying that he was in hand in glove with some client. That was the reason. I am not sure whether the authorities obtained a search warrant before such a search or recorded reasons for searching his office without warrant, because the search is immediately required. Something whether they have done it or not, I am not sure. So maybe this case will apply there also. Secondly, many authorities or officers may not know the correct procedure prescribed by law. They pass some exam, they occupy the chair, and they once they are in the chair, they think they are the gods. Their power is they have enough powers. That is what they think. The law enforcement needs to be properly educated or trained. That is my suggestion. My suggestion. I think it is ignorance. Because of the ignorance only, they have done everything and then seized the goods from ITC, and then the matter went up to Supreme Court. The point is, if they say they know the law, no, we all know the law, then if they violate it, it is serious in nature. Then it cannot be condoned. Law enforcement authority knows the law and violates the law. Then how can it be condoned? If they say I do not know the law, I do not know the procedure, then how can they enforce the law? That is the second point. Third point is, see the time wasted by the authorities and ITC also. Till up to Supreme Court, they have to fight. Even though single bench passes some order, division bench reverses it, and Supreme Court again reverses the division bench. All these things are happening. Entire time is complete waste of time for both the department and ITC. So that is my point. Thank you very much. Have a great day.